So now let's touch on the actual duty to inform law here in Indiana. And again, I remind you that this does not constitute legal advice. I'm not a lawyer. This information is for general information purposes only. This is our law in Indiana as of 2020. So it tells us that people living with HIV or hepatitis B have a duty to inform our sexual and needle sharing partners of our status prior to a high-risk transmission activity. The law was updated in 2020 to add an improved definition for high-risk activity. That means, according to the CDC, it's an act that bears a significant risk of transmitting HIV or hepatitis B. And we added those words to ensure the law reflected advances in HIV prevention that have taken place over time, such as the science of undetectable equals untransmittable, otherwise known as U equals U. U equals U means a person who is on treatment and HIV undetectable cannot sexually transmit HIV. This was intended to make it clearer that the person with an undetectable viral load is not legally required to disclose under Indiana's law because there is no risk of transmission. It is not a high-risk act. We also did it because we know that acts like oral sex have low to no risk of transmission. And furthermore, if people use condoms or one person is on PrEP, that could also be considered a legal defense under this new wording. All of this was done really as part of our mission to align our laws with current science and medical understanding around HIV transmission. So if I were charged under this law, I would get a copy of the previous slide and the actual wording of the law, and I would sit down with my lawyer, and we would go to the CDC website because I want them to understand the science and to see where the CDC endorses that these are not high-risk activities. So a person living with HIV who's on treatment and maintains an undetectable viral load has zero risk of transmitting HIV. It's endorsed by the CDC. Same thing with safer sex. The CDC website states that there is extremely low to no risk of transmitting HIV through activities like oral sex. On another place on the website, it actually says no risk activity. Same thing with condoms. It reduces the risk to where sex is no longer a high-risk activity. Then if the other person is on PrEP, the CDC states that this is about 99% effective when taken as prescribed. And of course, if we combine any of these steps, so if the other person is on PrEP and we use condoms, then we're able to show that we're further reducing that risk. And that's information that I want my lawyer to have so they can make the best case for me. In summary, if a person is undetectable, there is no risk of transmission. So there's no legal requirement in Indiana to disclose their status to sexual partners. There may be other reasons someone chooses to disclose. They may not completely trust the system, or they may have an ethical or moral driver to disclose, or they may just want to be safe and go ahead and disclose. In those cases, it's important that they learn to document that conversation should they ever be wrongfully charged. We'll go over tips and tricks for that in a later section. We do want to be really careful to support those who are not virally suppressed. There may be barriers to treatment that get in their way. There may be other things going on in their lives where taking a regular medication isn't at the top of their priority list. We do want them to understand their legal requirements and how to best have those conversations and to document them to protect against false accusations. We want them to know that if they use protection like condoms or they know the other person is on PrEP, that significantly reduces the risk of transmission, and they may have a case if for some reason they chose not to disclose. As we've said before, in an ideal world, we'd have an intentional disease transmission law that would require intent, some ill motive or desire to hurt someone else, and actual transmission. Today, our law requires neither.